We had some introduction to what is the concept of theory and what's the concept of intellectual property. So we started the class with the discussion of the concept of theory, and this description given for this concept was: theory is a supposition or system of ideas intended to explain something, especially one based on general principle independent of the thing to be explained. So, uh, theory is an account of statements which explains a thing. This is what discussed in the last class, and we went into the topic of intellectual property theories, and we started with the question why an intellectual property system exists. What's the need of the intellectual property system? And Sir gave a reason that economic importance of the intellectual property is a main reason for its existence, and the economic importance of intellectual property makes it a global trading commodity also. And why intellectual property right is given means the reason is the intellectual property right is a quid pro quo, a consideration for the intellectual labor, time, and money invested. And we then went into that concept of theories which justify intellectual property. And there are mainly three theories. First one is right-based justifications. Second one is economic justifications. And third one is consequential justifications. And then we went into the early thought regarding the intellectual property justifications, or theories which substantiates the requirement of intellectual property, the establishment of intellectual property. And we started with the definition of Blackstone, and Blackstone had justified as the individual has equal right over the objects in nature. It was accepted that the first occupier gets a right to it against others. This theory is dealing with the concept of private property system generally, and not the intellectual property system specifically. But this theory is revisited to provide a justification to the current intellectual property system. Then we went into the concept of labor theory propounded by John Locke in his famous book, The Two Treatises on Government. In this book, it is said that the person who puts labor on something which is freely available is the best person to own it. The property has to be used to its best. For that, the best person should deal with that land or with that property. John Locke imagines about how private property system was established. He justifies the allocation of property in this more advanced money economy by tacit consent. For Locke, positive laws that manifest disproportionate and unequal possession of the earth derive their authority from the tacit consent that people have given to be governed. So that's about my presentation. And today, Lawwellman sir will continue with the so it's told that he will continue with the personality theory. So I hand over the mic to Lawwellman sir. Thank you, sir.
Thank you. Thank you. Very good morning to everyone. Thank you very much, Mr. Renzi, my young friend, for having introduced or given a recap of what we discussed in the last class. My dear friend Safi sir, the coordinator Raniel Niada, Sherin, who coordinates things with me as far as intellectual property is concerned, and all the esteemed participants of the program. Once again, a very good morning to everyone. So we will be discussing, or we will be continuing our discussion on intellectual property rights. So I'll just take a moment to share my screen so that Is the screen visible?
Yes, sir.
Yes, sir. Yes.
Yeah. Thank you so much. Thank you so much. So, as Mr. Renzi has already put across, we were discussing theories of intellectual property rights. There are different theories, propounded by different people, justifying the institutional property. Intellectual property is also a property. So there are different theories. There are different philosophers who try to justify the system of intellectual property. So we have very many theories, and there are a few theories which are considered as appropriate for intellectual property. And what we were discussing, the theories or justification for intellectual property from using those theories. In fact, the theory we were discussing in the last class when we stopped our discussion, was John Locke's labor theory. In fact, as Mr. Renzi was also making it clear, that was not a theory propounded exclusively for intellectual property, but that theory is made use by the subsequent philosophers, subsequent theorists, to use to justify the institution of intellectual property, and that is found to be appropriate to the appropriate, or at least explained to be appropriate for justifying intellectual property. Why intellectual property system is existing. So we were half the way through on John Locke's theory, and we have to discuss personality theory also in this class, and then we will move to the ideas of copyright. And that's our plan of action for the day. And let's just flick through the slides which Mr. Renzi has already shown to you. But these were the slides which we went through. Like, what is a theory? Theory is a kind of justification for something. So intellectual property system is existing. What's the justification for that? That's a theory. Why IP system? That's what IP theories try to explain. And as we said, it is a quid pro quo, and these things have already been discussed, and it has been recapped. So we won't spend much time on that because we don't have time constraints also. So this is where we were just when we broke our class on the last day. John Locke's labor theory, which he propounded in his book, Two Treatises on Government. So, Two Treatises on Government is book, and he has propounded theory of property, and it is based on labor. Actually, he said any person who is putting labor and acquiring something from the common. No, he was just thinking of a state of nature where everything is in abundance and everything is common. Everything is available to everyone. Nobody is having any special right to that. And any person putting his labor and appropriate something, like plucking an apple, that's an example he gives, that becomes his. So transporting this idea to intellectual property, what we can see is the wild of ideas, the forest of ideas, the idea of nature, or the ideas that are available in the nature, in the sense, the imaginary nature, the imaginary world. And ideas do not belong to anyone specifically. It belongs to you, it belongs to me, it belongs to everyone in common. And when I acquire an idea, I appropriate an idea, and based on an idea, if I write a book on intellectual property rights, or if if Edison appropriates an idea and comes out with electric bulb, what happens is the idea of nature, which is available in common, as in the case of as in the case of the theory of John Locke, these ideas are also available to everyone in common. That's how he's trying to, or the subsequent theorists is trying to justify the system of intellectual property based on a theory which was propounded for some other purpose. So John Locke justified the allocation of property in this more advanced inequality, haves and have-nots. And some people have so much of property, and some people have very less, or some people are without fully into poverty. So this system, or what you can say is, this system is justified by John Locke by saying that a tacit consent is given by others for these rich people to make use of ideas or property. So this tacit consent, which is very unrealistic, it is being criticized also because the present system was to be explained. That was his intention. John Locke was trying to explain the present system. The present system, we can definitely say that there are no, there are inequalities, there is poverty, there is haves, and there are have-nots also. So that such a system can be explained only with this, because the have-nots have given consent for the haves to have more. That's how he is trying to explain that concept of property that time. But this is being transported to made use for the purpose of explaining intellectual property system also. Now coming to the second paragraph, which is available on screen, which I invite your attention to. And for John Locke, positive laws that manifest disproportionate and unequal possession of the earth, because presently the earth and the riches are not equally distributed. I may have more money, you may not have, and another person will have much more. And such a system derive their authority from the tacit consent that people have given to the government. Such a system no, or is allowed to exist because of the tacit consent. If a person is appropriating more, then he can have more riches. That's the idea is trying to propose. And it can be seen that when we go more into it, Locke's overall scheme for property, including intellectual property, can be viewed as an ally of the ideas of labor and tacit consent. So there are two ideas mainly. The one idea is labor, a person who is making use of his labor. Here, in the case of intellectual property, it is the intellectual labor from the nature of the common ideas. Somebody is making use of that, and he's coming out with a copyrightable item. Somebody is coming out with a patent item. So the justification for the patent system is that ideas were available in common, but nobody else laid his or her hands on that, and it is me, or it is person A was laid his hands, laid no, applied his mind to that, and he has put his intellectual labor in, and he has come out with a book. So copyright is justified that way, or patent is justified in a similar way, and the unequal distribution is justified by using the idea of tacit consent, which is, to me at least, very unrealistic, and it is being criticized also. But we are just trying to understand the theory. So there are two main things which are involved in intellectual property justification system of labor or John Locke's labor. Those are, first one, the idea of labor, based on which the property originates, and the unequal distribution, which is the present system, is justified using tacit consent. So labor and tacit consent are the alloys using which the labor theory of John Locke is built. That's how we should understand it. Modern writers have debated how much importance should be put on this hypothetical consent. Tacit consent have been heavily criticized also, but this is how John Locke has put that across. That's what we should understand, and that can be used in the that can be used for the purpose of explaining the intellectual property system and its its very existence also. That's a possibility. Now, no, John Locke's theory and IP. The cultivation of ideas demands a person's labor. I've already said about this. So, an idea can be a person will have to invest a lot of thought so as to have an idea in a matured way, which can be practically used. So, we are just applying Locke's theory into IP system, for IP system, and these ideas are appropriate. So a scientist, a writer will appropriate these ideas from a common which is not significantly devalued by the ideas removal. Just because a few ideas have been taken, then no, common will not be devalued. The ideas are available. Ideas will continue to be available in abundance in the common nature. So ideas are removed by this person, and he's putting his labor to it. and he's coming out with a useful thing, which we can call as intellectual property, copyright, patent, etc. So that's how we apply it. The idea can create property without breaching the non-waste condition. John Locke also speaks about the non-waste condition. Waste should not be there. Waste of property or waste of resources that is available in common should not happen, or there should be minimum waste. And that is also possible in the case of ideas. Ideas are available in the virtual world, virtual mind world, perhaps virtual mind world. And what you see is from that I'm appropriating something, and I'm not wasting anything. It's rest of the things or even that itself is available to others to appropriate in a different way. So the non-waste condition is complied with. There is no waste happening in the case of the common ideas, which is a major concern of John Locke, and he's speaking much more about it. We may not go much into it because we have an aim of an examination in mind, so we may not spend much time on theories. So Richard Epstein is attempting to provide a possession-based interpretation of Locke. So this is an interpretation given by another person for John Locke. So that's the reason why I put it in a different color, in violet. Richard Epstein attempts to provide a possession-based interpretation of John Locke's theory. And Epstein argues that first possession, because possession, the ideas are available in the virtual mind world, virtual world. And he argues that first possession forms the basis of legal title. Any person who is grabbing that idea for the first time, first possession from that world, is the basis for legal title. And he believes, or he is trying to interpret the theory, Locke's theory, and he believes that this is the heart of Locke's position. Locke's theory's heart is this: the person who is putting his labor so as to grab that, who is grabbing first, will have the legal title. That's how the theory goes. That's how it is understood, and it's being applied by Richard Epstein in the intellectual property context. Now, if you go further on Lockean explanation, the labor theory, the Lockean explanation of intellectual property has immediate intuitive appeal. If we apply our mind to the present, if we understand the intellectual property system, which we have already done, and if you're just trying to apply John Locke's theory to intellectual property system, it seems as though people do work, intellectual laborers, scientists, and people, the intellectual property producers, do work to produce ideas, or produce from ideas also, produce based on ideas, and that the value of these ideas depends solely upon the individual's mental work. And the impression we get is this: this is right. The ideas are available in common. Anybody can grab it. Anybody can develop it. That way, there is a total egalitarian system available. That's a feeling you get, but that may not be the actual system, because in order to develop an idea, you require a lot of investment, which is not available with everyone. I may not have so much of investment. Just because I've got a good idea, I may not be able to come out with an intellectual property, just because I do not have enough investment with me. So intellectual property system is not solely based on ideas alone. It depends on the money available with you, the investment available with you, which is available with the capitalists and the big shots. That's something which we should be keeping in mind. But otherwise, if we are thinking from a theoretical perspective, this has a lot of appeal, because you feel that anybody can grab an idea and anybody can create an intellectual property. That way, you feel that Lockean principle can justify the present intellectual property system. That's a feeling you get, but you should be doing that with caution. That investment of system and its existence as it is today. So the production of ideas and production based on idea. So that goes well with intellectual property system. The notion of appropriation of idea by somebody, intellectual laborer, and distributive justice. It's available to everyone. There is egalitarian kind of distribution available in the case of ideas. in common. That's also appealing. This is how you may interpret a theory, so as to fit that for an already existing system. So there are criticism. It's not without criticisms. The first criticism is the unequal distribution. The unequal distribution, even in the case of intellectual property, that we can perceive. That is the reality, and that is being justified by the idea of tacit consent. Tacit consent, which and I've given consent. I am a poor person. I've given consent for others to appropriate more and to be rich. I decided to be poor, but that's how it goes, which is not the reality. This is just a justification, just a technical justification for the existing system. And because of that itself, it lacks fairness. That is one of the criticisms that is put against the people who are trying to justify intellectual property system based on John Locke's theory. Now, you can. There are much more to discuss about John Locke's theory, but I think the basic ideas have been put across, and this much would be enough as far as your examination is concerned. So we'll move on to another theory, which is
So,
also
may I ask you a doubt, sir?
yeah, please, Miss
Sir,
Deepthi.
John Locke in the labor theory, does it justify the recognition of geographical indications, sir?
You're not audible. Yeah, Deepthi, Miss
Yes,
Deepthi.
sir. Am I audible, sir?
Now you are. Now you are.
Okay, sir. My question is, does the labor theory in any way justify the recognition of geographical indications, sir, as an IP?
Yeah, it's not only a good question, first of all. Now, there are things, trademark also. So, if you're trying to understand a justification, if you're trying to understand a justification for geographical indication or even for trademark, those systems are based on the labor theory. Because labor theory, at least in theory, gives importance to labor. And both in the case of trademark and as you rightly put it, in the case of geographical indication also, you cannot see immediate labor going into the production of this. Coming to your question specifically, if it in the case of geographical indication, can we justify a geographical indication system based on labor theory? I would say that in the gone by generations, the past generations, some people, when it comes to Aramula mirror, that would be one of the best examples. Some people have put their labor, which nobody else had done. Now it is not the labor of the present generation. Some people of forefathers of these people, the present people, had put some labor for the production of for having such a quality mirror. So that labor is being recognized now, and the people who are entitled for that, the people who are entitled for it as successors, are being given the right. So that way, this is just my explanation, but I think it's a reasonable explanation. That way, you can think of giving no justification for when geographical indication. But I find it most difficult to explain the trademark. In the case of trademark, at the most, what you do is, if I am just coining a trademark, what I'll do is I'll just design a trademark. If you think of Tata, it is just a T within a circle. You do not require a lot of labor in that. What you really require is the investment, and investment cannot be justified by no what you call the Locke's labor theory. So to some extent, geographical indication can be justified using labor theory. That is my thinking. In the case of it's very more difficult in the case of trademark. It's good that you raise the question, and but whenever we think of intellectual property, we consider copyright and patent as the most appropriate candidates to be called as intellectual property. So we take those as examples and just try to theorize and try to offer justification. Your point is valid, and this is how I respond to that. This is how I look at it, Miss Deepthi.
താങ്ക് യു സർ. പക്ഷേ സർ ജീരകശാല മാതിരിയുള്ള ചില കാര്യങ്ങളില്ലേ ജോഗ്രഫിക്കൽ ഇൻഡിക്കേഷൻ ഉള്ള,
Yeah,
so that
yeah.
actually does not require that much labor. ആറന്മുള കണ്ണടിന്ന് കുറച്ച് ഡിസ്റ്റിങ്ക്റ്റ് ആണല്ലോ അങ്ങനത്തെ ജോഗ്രഫിക്കൽ ഇൻഡിക്കേഷൻസ് വരുമ്പോൾ.
There are two kinds of geography indication. It's not that we are not aware. We are aware that there are two kinds of geographical indication, you can say, wherein one is manufactured products and other one is natural products. Natural products like Jiragasala or even what do you call the tea, what do you call, what is that? I just slipped the name. The Darjeeling tea or whatever it is. So those are natural products. In the case of natural products, you cannot say, you may not be able to justify it the way I justified. I was just trying to offer a justification to at least to some extent. In the case of manufactured products, which are entitled for geographical indication tag, and if it is, as you rightly put it, if it is a natural product, of course it is difficult to justify natural product based on GI, based on labor theory. You have a point, and I agree with you.
Thank you, sir.
Thank you. You are most welcome. Thank you. And thank you for raising the question. I was going a little faster. I was just did not dwell on these kinds of things because I was keeping in mind, as everyone does, I was keeping in mind copyright and patent more as the most appropriate candidates of intellectual property to justify this. Okay, thank you so much. So we have next theory to be applied. We'll just try to understand how it is being applied. We'll be going brief, but we'll be doing that. It is the utilitarian theory. It is Bentham who is the sultan of that, as you know. We might have learned that with interpretation paper. So here the idea is highest utility for highest number. Happiness of highest number is the basic idea. We may not go much into it. So applying utilitarian concept to intellectual property rights, that's what we are trying to do. It is interpreted, again, Bentham might not have thought of intellectual property when speaking about all these, but what we are doing is we are reinterpreting, or people have done reinterpretation of utilitarian ideas for the purpose of offering justification for intellectual property. So it is interpreted that by allowing creator, the copyright owner or the patent owner, the inventor and the author, I would say, creator, to profit from his work. I've written a book. I have come out with an invention. So what happens is, it is interpreted that by allowing creator to profit from his work, monetary incentives are afforded to the technological innovation and artistic creation, which typically benefit the society and humankind at large. So what happens is, a person is coming out with something, a person is given incentive or something in return for a book, for an innovation which gives some comfort, benefit for the society. So highest utility to highest number. So you are given incentive as an author in the form of copyright, so that you will write more and more books, and it is useful to the society. And you are given incentive in the form of a patent for your technological innovation, because then you will come out with more and more patentable invention, which will be useful to the society, and society will be happy, and society will be benefited of the utility at large. So that way, intellectual property system is being justified using utilitarian theory. It is an incentive. It is something a quid pro quo. It's a kind of encouragement for creation of something more and more useful to the society. And again, here even trademark and geographication and those kinds of things may not fully fit into this explanation. We acknowledge that, but in the case of other things, it might. So this is the basic idea of utilitarian theory for intellectual property, for justifying intellectual property system. This is how you may have to understand. And now we have another theory which is used more more than almost equally with that of John Locke's labor theory for what you call for offering justification for intellectual property rights. That is the personality theory of Hegel, a German philosopher who has influenced even Karl Marx. What happens is he says that property is a kind of extension of personality of uh, of of the creator. Let's think more about this. It goes like this. See, if I have extended my personality to something, to 10 cents of land or a movable thing, which was available in common to everyone, and I was the first one to apply my personality to to have a glance at it, to apply my personality, extend my personality, so that becomes mine, or rather, in a way, I possess it. I'm the first person to say that it's mine. I've done something to show that it's mine. I'm the one who has applied my personality to that first. So it becomes part of my personality, or rather, I'm applying personality to that. This could be better said. It is based on occupation and possession. As far as America is concerned, United States of America is concerned, perhaps Columbus is the first person. Of course, Red Indians were there, at least in the modern, the so-called cultured modern international world. It was Columbus who applied mind to the American colonies for the first time. But rather, or a person who is applying his mind and mind to an apple which is available in common, that becomes his part of his personality. That way, it is personality theory which is used for making it justifying intellectual property. And personality theory may be more appropriate as far as intellectual property is concerned, because ideas can be possessed better. When you say personality, it is not just physical personality, it is applying your mind also. So if ideas are available in common, then it is better to possess ideas than even physical possession. So that way, you are the first writer who thought about writing on what do you call first independence, the first struggle of independence, or you are the first one who thought of writing about organic theory, or you are possessing an idea as an author for the first time, and you are applying your mind to that. You're possessing that idea. You're extending your personality of that, and you call many of your intellectual creations are as the brainchild. That way you can understand it better. That's one of the ways in which you can understand it. So it is based on possession and occupation. The other one was based on labor, of course, on occupation also. But personality theory is based on occupation and possession. It is put across by Hegel. No, I'm being brief on this. And if you read further on this theory centers on an individual's personality and external extensions thereof. Extension of personality. When you write something, you are extending your personality. You are giving an external expression to your personality. In order to apply personality theory, there must be an intimate and or emotional connection between the author, creator, and his work or invention. That kind of an emotional connection. Brainchild. That's a reason why I was using the terminology phrase brainchild. So when you come out with a book, that's what you do. When you invent something, you have a connection with that. It comes out of your mind, and it is considered as an extension of your mental ability, and as it has come through your mind, it is extension of your personality. This will be perhaps this is also equally justifying the system of intellectual property. Again, it may not fully justify the unequal distribution of wealth, etc. But let's understand that it can offer a justification for intellectual property in this way. Now we'll just make a mention of somebody. Can Deepti read the name of the person here? This is just a lighter, take it in a lighter way. The person.
Peter, is it? I'm not sure about the pronunciation, sir.
Yeah, this is how I also pronounce it. He also has come out with a theory. I'm sorry, it's good that somebody else also read that. The perception this person has is more in the economic angle. Again, he says that an economically useful thing, creation, which could be a technological innovation. We have copyright and patent as the main candidates of intellectual property. And from this angle, somebody is trying to justify intellectual property system. Then he says that it is gives economic return to the creator, or at least the person who is behind the inventor, behind the author, is the society. It has a utilitarian line of thinking, but he also has come out with a theory. So the two main theories, as far as intellectual property system is concerned, are the labor theory of Locke and the personality theory of Hegel. These are the main theories put across. And I know one of my friends, my close friends, is working on propounding another theory, or at least trying to reinterpret a theory for giving for giving a justification for intellectual property. You might know that friend of mine who is to interact with you with the law of tort, etc. Vidit sir is working on this. Vidit sir is trying to offer a new justification for intellectual property using justice as fairness principle. And I am not supposed to disclose much more. I'll just stop there, and we may conclude our discussion on the theories of intellectual property here. And if you have any questions, I think I can respond to that. Otherwise, we'll move to the ideas of copyright. Do you have anything to contribute? Do you have anything to raise as Deepti raised? You're most welcome for that. We have a few moments for it. Any comments, any questions, any clarifications, any dissents from what I said, what I was trying to discuss? So I think...
Sir,
yeah,
can you please mention once again about the tacit agreement, sir? Once again, just in one sentence, sir.
What? No, I didn't get you. You were not audible.
Tacit agreement you were mentioning, no, sir?
Yeah.
Can you please, in one sentence, can you please tell what is the tacit
consent? It is not tacit agreement, of course. I know where tacit agreement. The tacit consent is an idea in labor theory of John Locke. So here, what we see is in the present world, there is very unequal distribution of property, be it intellectual property, be it any other kind of property. So if you are trying to justify the present system of unequal reality, if you are trying to justify unequal reality using this theory, you may have to say that John Locke has said, that some people are rich, some people have more property, and some people have less property, and some people have no property, because the rich people are allowed, or at least given a tacit consent, to have more property by others in the society. So that's the reason why they are in a position to amass wealth. He was just trying to justify the present system of unequal distribution, and he was not ready for redistribution. So if things were all the things were in common, as he said in the as he said earlier, in the in nature, as a common thing, where everything is available in common. If that reality is taken to be true, then all the people are equally entitled for that. All people should be entitled for all the property. And here the system is different. There are there is a very unequal, unjustifiable system. Rich, poor, medium, all kind of people are there. So such a system, such a reality can be explained using this theory, only using the principle, much criticized principle of tacit consent. A poor person gave consent, tacit consent. At least he did not go against it, as he has not raised a complaint against it. So he has given a tacit consent. Consent without, tacit. The word tacit means that it is not expressed, but silently, or at least without opposing, he gave a consent. So the idea of tacit consent is the basis of inequality in the society. That's how John Locke has said, and that's how even the present intellectual property system can be understood. That's how it should be understood.
Thank you, sir. Well said, sir.
I think the idea is put across. If it is not clear, you can be very frank and
No,
ask
sir,
me again.
very clear, sir. Thank you, sir.
Thank you so much. Okay, so I think we do not have other questions to answer now. So we will move to another one. We will move to another area. Is the screen visible? Slide visible?
Yes, sir.
Slide is visible, right? So we were on general things on intellectual property. Now we are going to be very specific. We are going to be specific. We are generally speaking about intellectual property system. We were generally speaking about the justification for intellectual property system. We were generally speaking about the international conventions and things like that. We were just generally trying to understand the commercial angle of intellectual property and things like that. So if we specifically ask the question, what are the items included in intellectual property? We have the list here, which we have already seen. We have as many as 8 items in intellectual property. The 8 items you might already remember, but just to put things in that proper perspective, we've just list that out. You can see that on the screen. The main items, the items of intellectual property are copyright. I'm sorry. Yes, there was some technical problem, network issue. So Perhaps copyright is the most popular one among intellectual property rights. You might have learned about that in your LLB undergraduate classes also. Some of you might be coming to copyright at an LLB level. That's all. So others may please excuse. So we'll start with a simple statement about copyright. Copyright system, we would say, aims at providing protection to others on their creation. We'll write it and we'll read it once again. Copyright system aims at providing protection to others, like writers, artists, music composers, film makers, etc., on their creation. Such creations are usually termed as work. That's his work. The painting is a good word. That's how we say. And the terminology work is used by copyright law also. It indicates the manifestation of an intellectual work. It is musical work, literary work, artistic work, etc. That's how it goes. And now if we ask further the questions, why copyright? Copyright contributes to creativity by giving creators incentives in the form of recognition and fair economic rewards. This goes well with the very idea of intellectual property which we discussed earlier. So this is a kind of quid pro quo, you can say. It's a kind of incentive, you can say. You can say it's a recognition for the creator. You can also say that it gives a fair economic reward to the author or the creator in the case of copyright. Under this system, under the copyright system of rights, what you give as right, copyright, as a bundle of rights, creators are assured that their works can be disseminated without fear of unauthorized copying or piracy. As I wrote a book and as I have a copyright in it, without any fear of somebody else making use of this, I can print and publish my book because I've got legal protection called copyright. And justification for that is that I'm the person who grabbed the idea and have come out with a manifestation of idea in the form of a book. So I have copyright. Now this is the thing which represents copyright all through the world, I feel. And that's the way in which I understand is that you created something and you have a boundary around that, nobody else can touch it. This is a informal way of understanding it. And the law dealing with copyright in India, you might already know, it is Copyright Act 1957. And our discussion will be mainly based on Copyright Act 1957. Now, coming to subject matters of copyright, what's being protected as copyright? What are copyrightable items? What kind of an expression of yours will be entitled for copyright? So subject matter or subject matters of copyright. Now that is discussed under section 13 of the Copyright Act 1957. And there are as many as 6 items identified under section 13. And those items are, first one is literary work, second one artistic work, third one dramatic work, fourth one musical work, fifth one sound recording, and the sixth one is cinematography. These are the 6 items in which copyright to exist. Unless you are in a position of these categories or can be categorized as any of these, you don't have copyright. So in order to understand the system of copyright, we need to have an understanding of these 6 items. And we are going to do that. Now, the first one in the list is literary work. The obvious question is, what is a literary work? I've got an example I don't want an answer for this, but I want all of you to say this. You will not. If I raise the question, is this a literary work? You will never have a doubt to answer in affirmative. You can definitely say that this is a literary work. The God of Small Things by Arundhati Roy. Now I've got another example, which is available on screen. I hope it is visible. This is a mathematics and statistics textbook, a foreign book from Indian perspective. If I ask the question, is this a literary work? As an ordinary person, if you have not gone into intellectual property and if you have not gone into copyright, you will definitely be at least a little doubtful whether this is a literary work or not. Because this is mathematics, and as our commonsensical understanding goes, and if you flip through a dictionary for the purpose of understanding the meaning of literary, it may not go well with an understanding of mathematics textbook. Literary work should have literary quality. That's the understanding we have. And if we go by that commonsensical, the ordinary understanding of literary work, mathematics textbook will be out of copyright. Meaning to say, it will not be entitled for copyright, it will not be entitled for protection. And the consequences will be such mathematics textbooks, at least theoretically, mathematics textbooks will not be created, because if mathematics textbooks are created, then the person and of course the company, the publisher company, will not get any protection exclusive right. So there is no incentive, at least in theory, to create more and more mathematics textbooks. And ultimately, further, if you build further, if you think further, then the society is being denied of an opportunity which it otherwise would have had. So that will be the consequence. So copyright law has a different approach and different agenda. Copyright law says that any book, any creation of this sort, behind which, if there is intellectual labor and if there is investment behind it, if there is intellectual labor and investment behind it, then there is copyright. Importantly, notably, there need not be any literary quality. Literary quality is not one of the criterion to decide whether it is a literary work or not. It is a material whether it has got literary quality or not. What's important here is whether there is intellectual labor and whether there is investment. And if you apply these two principles to mathematics textbook and to any copyrightable work, answer will definitely be affirmative. Then you will be comfortable. You will be comfortable in saying that. You can comfortably say that even a mathematics textbook, the creation and behind which there is a lot of intellectual labor, and behind which there is behind the publication of which there is investment. You can definitely say that even a mathematics textbook is a copyrightable item, and that is the requirement of the industry also. So anything in print and writing will be entitled for copyright as a literary work. So if we go for a listing out, a book of any sort, a novel, poem, textbook, anything could be a literary work. A letter could be a literary work. A letter written by a great father to his daughter or anyone could be a literary work. Question paper could be a literary work. Answer scripts could be literary works. Abridgments of a bigger one to a smaller one, abridgment, a compilation of a lot of data together. An edited book could be a literary work. An encyclopedia will be literary work, because there is industry behind this. There is industry who are creating all these, who require protection for this. It is for the industry also that copyright law is existing the way it is existing now. An encyclopedia is entitled for copyright protection as literary work. Dictionaries are entitled for copyright protection, and notably, just see the last item, even software. A computer program is entitled for copyright protection, notably as a literary work. Because one of the ways in which you look at it is even that is written in a language. There is human creation behind it, human labor behind it, a lot of investment into it. And more importantly, there is a big industry crying for protection, making you and cry for protection. So an interpretation is given, or copyright law encompasses even software in the fold of literary work. Now, going further with this, we have to understand further the idea of literary work. You have an important case. I think perhaps this could be the last idea for the day. This is the most important case on the point, perhaps one of the most important cases in copyright law. Please don't miss this case. London University Press Limited versus University Tutorial Press Limited. London University Press Limited versus University Tutorial Press Limited. The question in this case, in this 1906 case, it's more than a century, it's an English case. Does literary work under copyright law require literary merit? The question is already answered in the last slide, but let's just hear it from a quote, which will be more authoritative. And this case is often quoted almost in all the copyright cases in India too. So the question in that case was, in 1906 was, does literary work under copyright law require literary merit? And here, if we go a little bit into facts of this case, it's like this. The mathematics question papers of London University was printed and published by a private publisher, University Tutorial Press Limited, without the permission of London University. So that was the position. Mathematics text, mathematics question paper. London University was not happy. They wanted to stop, and perhaps they might have approached them morally or otherwise. But the requests were turned down by the University Tutorial Press Limited, a private company. Then they had to go for legal action. They also might have approached a lawyer, and perhaps this is the innovation of a lawyer. And lawyer might have thought of including or trying to putting mathematics textbook into any of these copyrightable items. It is definitely not a musical work. It is definitely not a dramatic work. It is definitely not an artistic work. And perhaps he might have thought that the most appropriate category into which I can put this, or I can build my argument, could be based on literary work category. And he also might have argued that the agenda of copyright is not only to protect literary work, and if that be the agenda, then that will fail the system of copyright, because system of copyright is not only for the creators who create literary quality things, but any kind of creators. So he might have argued like that. Ultimately, the court came out with this observation, which is considered as classic, which is followed in our copyright law and also in almost in every case we come across in India. Literary work covers work which is expressed in print or writing, irrespective of the question whether the quality or style is high. This is the observation of the Court of Appeal, and it further says, after some observations in between. After that, it says, papers set by examiners, mathematics question paper examiners, are, in my opinion, in judge's opinion, literary work within the meaning of the present act, that act of the Act of England, which is similar to that of the present Act of India also. So our understanding should be this: in the case of copyright, literary work need not have literary quality in order to qualify to be called as literary work, so as to be eligible for copyright protection. So I think as the time allotted to me by Sherin, the organizers, is up to 11 o'clock, as the time has already crossed crossed 11. I think we'll stop our discussion on copyright for the day here, and we will continue with the discussion on copyright next 2 more days. I'm told by Sharon, who is organizing this, that we can spend some 3 to 4 hours on copyright. So that's how we are going, and I think we can stop the discussion on copyright for the day. So that's it. Thank you so much again, Safisa and the organizer Sharon, Ranlia, etc., for giving me this opportunity, I would say, to talk to the screen group, and also to the
Sir,
patient hearing of all
sir,
the participants. Thank you so much. If you have a question, definitely you can raise.
sir, John Locke theorem ഒന്നുകൂടെ പറയാൻ പറ്റുമോ?
John Locke's theory. Which part of the theory? The whole thing, or which part of that? Mr. Ransi, you want the entire thing once again, or?
സർ ഒന്ന് റഫായിട്ടൊന്ന് പറഞ്ഞാൽ മതിയാകും. റഫായിട്ടൊന്ന് പറഞ്ഞാൽ മതിയാകും.
Yeah. See, John Locke is an English philosopher, I would say. He was just trying to justify, offering justification for the present system. At that time, criticism. And what he did was,
Okay, sir.
he said what he has said in two treatises on gun. One of the chapters in two treatises on gun is this: the present system of property can be justified by saying that at one point of time, at the earliest point of time, all the things, the physical things he was referring to, all the things were available in common for everyone. There was no system of property. And at that point of time, the person who used his labor, which is out of his body, and one who grabbed something using his body, using some labor, was climbing an apple tree and plucking an apple. So there is some labor behind it, and that labor is his. And as he is the first one to climb on that and pluck that apple becomes his. So that's the basis of his theory. Similarly, we were applying that theory for the justification of intellectual property system. So if you take an author, what we can say is the ideas are available in common for grabbing. It could be grabbed by anyone. If I am an author and I feel that idea is good one, I am using my labor and writing a book on that. I'm coming out with a poem based on it. And if that is a position, I am using my labor, and as I am the person behind it, and that poem or that book becomes mine. Similar is the case with the patent. Anybody can make a machine, but that idea is available in common. Somebody is using his intellectual labor and trying to what is he doing is he's trying to come out with an expression. He's putting labor and coming out with an expression, coming out with a product based on that idea. So as he is the person who has made use of that idea for the first time, that becomes his. So that's how the intellectual property system is justified using John Locke's theory. But the problem with John Locke's theory is this: the unequal position. Maybe it could be justified by saying that the persons who have grabbed more ideas have got more property, and people who have grabbed less ideas have got less property. That way you can justify it. But that is very, that is very, what you call unrealistic, and that is being criticized also. This is the basic idea of John Locke, and this is the way in which John Locke's theory is used for the purpose of interpreting intellectual property system. Will that do, or do you require some more explanation? Mr. Ransi?
That's enough, sir. Thank you, sir. That's enough. Thank you, sir.
You're most welcome. Thank you. Thank you very much.
Okay, that's all for today's session. Thank you, Lawwellman sir, for your time. That's it. Does anyone have any doubts? Any more doubts? No, sir. I think there's no doubt. So once again, thank you all. Thank you all the participants. Thank you, Safi sir. Thank you, Lawwellman sir, and thank you, Raniel Nieta. Okay. Thank you.
Thank you.
Thank you, sir.
Thank you, Deepti. So I think with your permission, I'll also leave. Thank you so much.
Okay, sir. Thank you. Thank you so much.